The role of Speaker in State Legislative Assembly with relevant articles, Supreme Court judgments and amendments. Speaker of first we'll be having the Legislative Assembly, right? Legislative Assembly has a Speaker and then there is the Chairman for the Rajya Sabha. He or she is responsible for ensuring the smooth functioning of the legislative processes. The Speaker's responsibilities, powers, and duties are enshrined in the Constitution. It is mentioned in the Constitution. Various legislative acts has been further clarified through Supreme Court judgments and constitutional amendments. Now, for Speaker, we have Article 178 and 179. Speaker and Deputy Speaker are mentioned in the Constitution itself in Article 178 and 179. We further have Article 178, 179, left alone Article 180. Then we have 181. And the rules of procedure is separately mentioned in Article 208. So, four articles related to Speaker. Article 178, 79, 81 and 8. You have to remember 7 and 8. Okay. So, it begins in 78, 79 and then we have 181, 208. Article 180 is left right, but it is related to Deputy Speaker. That is why it is not mentioned over here. So if you combine Speaker and Deputy Speaker together, 178, 179, 180, 181, and then a different article is 208, which is related to the rules of procedure. Now here I am writing what is Article 180. We will be having the Deputy Speaker. Deputy Speaker, at what circumstances he performs the function of the Speaker. There needs to be a clarity. That is why these articles are mentioned in the Constitution itself. Article 178, 179, 180 is related to Deputy Speaker, 181, 208. So 180 is when the Deputy Speaker becomes a Speaker in the absence of the Speaker, right? So under what circumstances Deputy Speaker becomes a Speaker is mentioned in Article 180. Now 178, 179. Deputy Speaker and Speaker of Legislative Assembly. Every Legislative Assembly of the state, as soon as may be, choose two members. We need to choose two members. Okay, now here why I have mentioned related to the role of Speaker in the State Legislative Assembly. We don't have a chairman. Usually just few states have a State Legislative Council and its chairman. Predominantly Rajya Sabha has a chairman who is vice president. Now here we are dealing with the Speaker of the State Legislative Assembly because UPSC usually tends to ask provisions related to PM, Parliament. Now, with the changing trends, let us have a greater emphasis on CM, State Legislative Assembly. Right. That is why we have here 178, 179, 180, 181, 208 articles related to the Speaker. Every state legislative assembly, as soon as maybe it should choose two members of the assembly. First the speaker and the second one is the deputy speaker. And so often as the office of the speaker or deputy speaker becomes vacant, the assembly shall choose another member to the speaker and deputy speaker as the case may be. Right. Now we have to see with respect to vacancy, resignation and removal. The same things corresponds to Parliament Speaker. Articles alone varies. So those things are conventional. Here we are seeing things which are less important, but at present times they are having more relevance. Now when there is a vacation or resignation or even removal, So various terms are used here. First is vacation, then they resign is what we call it as resignation, and if they are removed. So the removal of the speaker is mentioned in Article 179 of the State Legislative Assembly, the Speaker of the State Legislative Assembly. 178 is very simple. As soon as the State Legislative Assembly commences, there needs to be a speaker and a deputy speaker. Article 179 is related to the vacate when there is an empty seat, and when they are resigning or they are subjected to removal, right? Now, when there is a vacation, resignation or removal of from the offices of speaker and deputy speaker, a member holding office as speaker or deputy speaker of an assembly shall vacate his office if he ceases to be the member of the assembly. When they should vacate, you are not a member of the assembly, automatically you should vacate that seat. You don't have any authority to hold that seat. So can you know the difference? When a person who is other than the member of state legislative assembly, only state legislative assembly. If you are not a member of state legislative assembly, you need to vacate. Then we have resignation. When do you resign? When you are not interested to be to hold that position. He is resigning to the deputy speaker. Deputy speaker will resign to the speaker under his hand addressed to speaker. Speaker resigns to deputy speaker and deputy speaker resigns to the speaker. Removed by passing majority of then members of the assembly. Here only the members of the assembly, that is then members of the assembly. This is called as relative majority. When there is a majority of the then members of the assembly, it is called as the effective majority, right? Effective majority is the majority of then members of the house is what we call it as the effective majority, provided that no resolution for the purpose shall be moved unless at least 14 days of notice. So the notice time which is given here is 14 days of notice. The then members of the assembly, majority of the then members of the assembly in the sense, when let us assume that the 300 is the total number of members. This is majority of total number of the members is 300. But few seats are vacant. 293 is the total strength. This is what we call it as the then members. Majority of 293 is 50%. Greater than 50% of 293 must vote in favor of removal. That is when the assembly passes the resolution. 14 days prior notice must be given for that resolution. So we know that Article 178 is when we have a speaker and a deputy speaker. 179 is the removal or when a seat is vacant. 180 is deputy speaker functioning. When they are removed, the deputy speaker needs to function as a speaker, right? When they are removed, the deputy speaker needs to function as a speaker. Next, we have Article 181. 181, the power of the deputy speaker. We have deputy speaker to perform the duties of the office as speaker. Here, when the office of the speaker is vacant, there is a slight change. This must be Article 180. So then Article 180 is also included. 180. Let me tell what 181 is. 181 is when there is a resolution for the removal of speaker, he shall not preside. This is what Article 181. This is Article 180. The power of the deputy speaker to perform the duties of the speaker when the office is vacant, and even if the deputy speaker is vacant, the role of the speaker is done by such a member of the assembly as the governor is going to appoint. If speaker is vacant, we have deputy speaker. If deputy speaker is vacant, here the governor, you have to note down, it is the governor must appoint, right? If they are absent is that is they are on the leave, assembly members choose among themselves one member as the speaker. So to appoint for the vacant post, we need governor and not the assembly. This must be very clear. Article 180 this is. When the speaker has a resolution for his removal resolution for the speaker, he shall not preside. This is same for the deputy speaker also. During the absence of the speaker from any of the sitting of the assembly, deputy speaker, or if he is even absent, person who is determined by the rules of procedure of the assembly. And if no such person is determined, other person may be determined by the assembly, shall act as the speaker. So absence is different from vacancy. Article 208 is the rules of procedure. Rules of procedure. A house of the legislature of the state may make rules for the regulating, subject to the provisions of the constitution, its procedure and conduct of its business. Until rules are made under clause 1, the rules of procedure and standing orders in force immediately before the commencement of the constitution with respect to the legislature for corresponding province shall have effect in relation to the legislature, subject to such modifications, adaptations as may be therein by the Speaker of the House. So, Speaker makes the rules of procedure. Now, we have few case, Quixote-Holohan case. Now, Speaker has an important responsibility of disqualifying a member on the basis of anti-defection. Anti-defection, right? Anti-defection is related to the 52nd Constitutional Amendment Act of 1985. So 5, 6 is 7, right? 1, 9, 8, 5, 7 is what? 5, 6. 52nd Constitutional Amendment Act 1985 is anti-defection law, and 91st Constitutional Amendment was also passed for anti-defection law. It is 2003. 91st Constitutional Amendment Act of 2003 is related to the anti-defection. Now, when we are speaking with respect to the speaker, we have Quixote-Holohan versus Zajilhu, 1992, right? The landmark case, anti-defection law under the 10th schedule is subject to judicial review, right? Speaker is the one who decides a disqualification under 10th schedule, but this speaker's decision is subject to judicial review. Quixote-Holohan versus Zajilhu. Navam Rebima versus Deputy Speaker, Arunachal Pradesh Legislative Assembly. Here in this case we have Supreme Court ruled that the Speaker's power to disqualify is not absolute and it is subject to judicial review. Reiteration of the Quixote-Holohan case, which is related to Quixote-Holohan case is related to judicial review. So you don't need to mention this case again and again. Just one case is enough. Rajaram Pal versus Speaker itself. Though related to Lok Sabha, this is related to Lok Sabha. This judgment sets out principles applicable to legislative bodies in general. The court held that Speaker's decision could be challenged in the court if they are unconstitutional, illegal, or violative of the principles of natural justice. Important amendments is 52nd Constitutional Amendment Act, which introduced the 10th schedule, which is 1985, introduction of the 10th schedule of the Constitution, known as anti-defection law, and it gave the Speaker of the State Legislative Assembly the authority to decide on questions of disqualifications on the members on the ground of defection. 91st Constitutional Amendment Act of 2003. This amendment further strengthened the anti-defection law by placing the cap on the size of Council of Ministers. So there is a cap on the size of Council of Ministers, not less than 15% of the strength of the Lok Sabha, right? Not greater than. Size of the Council of Ministers and ensuring that defectors cannot be appointed as ministers or hold remunerative political posts. Roles and responsibilities. They preside over every sessions, right? The Speaker presides over the meetings of Legislative Assembly, maintaining the order and decorum during the debates and discussions. Decisions on point of order. Point of order which is raised by the members to ensure the rules or procedures are followed. If the rules of the Lok Sabha, the rules of procedure of Lok Sabha or State Legislative Assembly or Rajya Sabha or the State Legislative Councils are not followed, they any member can raise a point of order to the respective head, that is the speaker or chairman. Point of order. He decides on the point of order. The speaker here of the state legislative assembly is article 178, 179, 180, 181 to not 8. Casting vote in case of tie. So first is he presides over the sessions. Casting vote. Point of order. Right. So we have the point of order. Certify the money bills. A speaker certifies whether a bill is a money bill or not, which is significant in determining the legislative process for the bill. This decision by the speaker is final. The speaker is the one who is deciding whether it is a money bill or not. His decision is final and it is not subject to the judicial review. Administrative functions. Various administrative responsibilities. Appointment of the staff to the assembly secretary. Administrative functions related to appointment of the staff. Anti-defection proceedings. Now, conclusion. The Speaker of the State Legislative Assembly holds a crucial role in ensuring the legislative body's effective and orderly functioning. The constitutional provisions, Supreme Court judgments, and amendments underscore the importance of the Speaker's role and provide a framework for their duties and powers. While the Speaker has significant authority, their actions are subject to judicial review to ensure the fairness and adherence to the constitutional principles. We have previous questions related to Attorney General. That question will be discussed further. But now here let us have a discussion on the Advocate General. Right? Advocate General is the Chief Legal Advisor. He is the Chief Legal Advisor. Attorney General is also the Chief Legal Advisor of the Union Government, and state, for the state we have Chief Legal Advisor is the Advocate General, and he is also the lawyer of the government of the state. Discuss. This is what the question is. Now this is actually a question. Here in this question we have to give a introduction and to include constitutional provisions for your ease. What So you can also write a question without referring to the answer by pausing the video. First, you know how to give a general introduction. What are the things which you need to include is constitutional provisions with respect to Advocate General. The Supreme Court judgments, if any, amendments related to Advocate General, if any. You have to provide a conclusion. Right, this is a very simple question because you don't have much stuff related to Supreme Court judgments or amendments. You have two constitutional provisions, where the first constitutional provisions is related to the Attorney General and the second provision is where he has certain privileges like participating and has the right to speak in the state legislative assembly. There's two provisions related to Advocate General. Now, the role of the Advocate General as Chief Legal Advisor of the state government. Advocate General is a constitutional office holder in India who serves as a Chief Legal Advisor and lawyer of the state government. They are called as constitutional office holders. See how unique the point is. This position is crucial in providing they provide legal advice, represent the states in the legal matter, safeguard its interest in courts. So all the points are all their work is mentioned here. First is they need to provide a legal advice, right? They provide a legal advice and they also represent the state. They are supposed to represent the state in legal matters. If there is a case in which the state is a party, there is a case against the state, or if the state is, putting a case, he represents the state in legal matter and also safeguard the interest in court. First, to advise and to represent the state, safeguard the interest in the court. The third one is related to the court. Now, let us look into the constitutional provisions. I told right there are only two constitutional provisions. 165 is with related to the appointment. 177. 165 is related to the appointment duties of the Advocate General of the state. Governor of each state. So each state is having a governor of each state shall appoint a person who is qualified to be appointed as a judge of the High Court to be the Advocate General for the state. Governor is appointing. A person. Okay. This person, what is the qualification? So first important point is the governor is appointing, not the president. So whenever you see the term governor or parliament, you have to relate it to their opposites or to their uh, related personalities. Governor, one person who is related to governor is president, who both of them has more or less similar roles, functions, right? Why the president is not appointing state legal advisor? You have to think like such. Because the president appoints many persons who function for the state. But why not legal advisor? Because the legal advisor is not he is a constitutional person, but it is not a constitutional post with respect to duration. He do not have a fixed tenure is not provided in the constitution. Right. So you can relate he is not having a fixed post. That is why maybe governor is appointing. You should keep some relations in your mind. The governor of each state shall appoint a person who is qualified to be appointed as judge to the High Court to be the Advocate General for the state. Governor is appointing and he is qualified as a judge of the High Court. So since it is a state, we have governor, and when the governor is present, we need to go for the High Court. Advocate General holds the office during the pleasure of the governor and shall receive remunerations which the governor determines. Now, what is Article 177? The provisions for the rights of Advocate General to speak and otherwise participate in the proceedings of the state legislature, but without the right to vote. He is not having a right to vote is denied over here. So the provisions for the right of Attorney General to speak in and otherwise participate in the proceedings of the state legislature but without the right to vote. Article 88. It grants immunity to the Advocate General in the exercise of his functions and powers under Article 165. So we have three articles. Article 88 is somehow related to Advocate General's immunity. I mean, Article 88 is for Attorney General. No, there is a mistake over here. This does not come here. Attorney General, and a similar article of immunity is mentioned in Article 177. Right. If you add 89 to 88, you will be arriving 177. So 88 and 76 is related to the Attorney General. 175, sorry, 165 and 177 is Advocate General. Now, he is the chief legal advisor, he is the defender of the state interest and the court and in the litigation management. You can use these terms, litigation management. Chief legal advisor. Attorney General, sorry, Advocate General advises the state government on legal matters, interprets the constitution and the laws, and represents the state in courts and tribunals. Litigation management manages and supervises all the legal proceedings in which the state government is a party or has an interest. Defender of the state's interest. Safeguards the legal interest of the states and ensure the compliance with legislative norms and constitutional provisions. We have again here three cases. These are related to Attorney General. I don't think these cases are important. And there is no amendment also. Legal guidance and representation, rule of law, protecting the state's interest, ensuring constitutional compliance. Okay, in case if we have some question, let us prepare for the adversary. Right. Supreme Court emphasized the role of Advocate General. It's actually Attorney General. You can bring Attorney General over here also. So this is Advocate General. Yeah, correct. This is Advocate General. This is Attorney General. Primary duty to assist the courts in arriving the decision rather than securing a victory for the state. He has to help or he has to assist the court in arriving a decision. He should not, convince them for the victory towards the state. Union of India versus Gandhi 2010. Rahul Gandhi 2010. Supreme Court clarified that the role of Attorney General is to assist the court. He must assist the court in arriving a decision rather than securing a victory. MP Jain vs State of Assam 1972. Advocate General role as constitutional functionality and highlighted they need to be impartiality and expertise. That's it. Now, the next question. Now we have started discussing questions, right? First question is related to the Advocate General. Now the second question over here is, does India needs presidential form of the government? Do we need a presidential form of the government? Answer, we need to answer with relevant articles, amendments, Supreme Court judgments, recommendations, provisions present in the government. India currently operates under the parliamentary system of the government. For parliamentary system of the government, we know Article 74 is where the Council of Ministers to aid and advise the President. So we have the Council of Ministers to aid and advise the President is what we have. Article 75 is when we have the Council of Ministers to aid and advise the President. Article 75, right? Sorry, 74, guys. To aid and advise the President. Article 75, the Prime Minister appointment. The Prime Minister is appointed by the President and other ministers are appointed and the Council of Ministers are appointed by the President on the advice of Prime Minister. Next, they are the Council of Ministers hold office under the pleasure of President. The fourth one is related to the Council of Ministers responsible to Lok Sabha. And fifth one is a minister who for any 6 consecutive months, if he is not a member of that either house of the parliament, shall at the expiration of that period cease to be a minister. Article 52, the President of India is the head of the state. It also belongs to the parliament. He is a member of the parliament, right? 53 to 78 is related to president. Includes the power to promulgate ordinances, appoint Supreme Court judges and pardoning powers. Of articles which are related to parliamentary and presidential form of government. Now this parliamentary form of the government is a key point in basic structures. It is one of the basic features. So we need to write the case related to the basic structure of the constitution. Cannot be altered, which includes the parliamentary form of government. This decision solidifies India's commitment to parliamentary democracy. Why we don't need to change to presidential form? Because parliamentary form of the government is a basic feature and the basic structure of the constitution cannot be altered, which includes a parliamentary form of government. This decision solidified India's commitments to the parliamentary democracy. Next is what we write 42nd Constitutional Amendment Act. It has expanded the scope of Prime Minister's powers and reinforced the parliamentary form of government. It has reinforced the parliamentary form of government. S.R. Bommai case is related to federalism and president's rule, the supremacy of the constitution and parliamentary democracy. Any attempt to change the basic structure of the constitution, including the form of the government, would be subject to judicial review. Recommendations for the stability. Presidential form of the government has provided stability by continuous and responsible government which is accountable to legislature. Responsibility, you can mention this as a responsibility. Whereas you in the presidential form you have stability. So instead of stability, presidential form of the government is having stability. Stability is not found in is weaken in responsible. Is weak in the parliamentary form of the government. So the responsible government, the parliamentary system in India has provided stability. It has provided stability by ensuring a continuous and responsible government which is accountable to the legislature. Accountability. The Prime Minister and the Council of Ministers are accountable to the Parliament, fostering the transparency and oversight. Cultural diversity. India's diversity and federal structure are accommodated well within the parliamentary system through mechanisms like federalism and regional representation. Then we have efficiency. Parliamentary system allows for the quick decision making and responsiveness to changing circumstances compared to potentially gridlocked nature of the Presidential system. Actually, you have quick decision making in the presidential system because parliamentary system needs consensus, right? So this can be used. These 3 points is enough, and these 3 points can be used. And against is executive authority. Clear separation of the powers. Presidential form of the government could provide a clear separation of the powers between the executive and the legislatures because the president and the council of the prime minister and the council of ministers are the executives and they are also the members of the legislature, right? Therefore, there is no clear separation of the powers between the executive, separation of the powers between the executive and the legislature. We have separation of the powers between the executive and judiciary in DPSP Article 50. But there is no clear separation of the powers between the executive and the legislature, with the president serving as both the head of the state and the head of the government as well. But here we have the head of the government as prime minister in India in the parliamentary system. But when there is a presidential system, the president will serve as both the head of the state as well as the head of the government. Direct elections, directly elected president may be stronger mandate compared to the prime minister chosen by majority party. Stability, presidential system is fixed which provides more stability, continuity in the governance. With the presidential form of the government, offers advantages such as clarity in executive authority, there is stability through fixed terms. Indian parliamentary system has provided effective in managing its diverse population and a federal structure. We have better center state relations because the states are members of the legislature and they are onto the decision making. The constitutional provisions and amendments of Supreme Court judgments reinforce the parliamentary system as integral to India's democratic framework. Any consideration for a shift to the presidential system would require democrat- substantial constitutional amendments and careful consideration of its implications for governance, stability, and democratic principles upheld by the Indian Constitution. This Thus, while the debate continues, India's current parliamentary system will remain deeply rooted in the constitutional ethos and has demonstrated adaptability, resilience in meeting the country's governance needs. Critically examine the separation of the power in the Indian Constitution. Key features of the separation of the powers. Executive, that is, the president is right. President is having the articles under 52 to 78. Then we need to mention legislative articles is under 79 to 122. Judicial is 124 to 147. This is 7 and here is 7. 9. Just two articles, right? 79 to 122. So just 2 is the difference, therefore 122. Now we have here 4. 4. 124 to 147. 50. It begins from 50. 52 to 78, the next article here 79 to 2 is the difference, 1 to 2, 1 to 4 and 1 4 is here and then we have 7, the no numbers only, 2 2 7 7 5 and 8 4 9. So how do we memorize our articles? 5 2 2 7 8 7 9 1 2 2 1 2. Now we have here also 4, so 4 7. So this is related to the executive branch because we deal with the separation of the powers, and this is legislative branch, and here we have the judiciary branch, right? President is the head of the state. He he is a ceremonial head, head of the state, but he is a ceremonial head. They both are executives, right? Include the important functions such as appointment of the prime ministers and also the appointment of the governors. So what do you mention about the president? President is going to be the head of the state, and his powers are ceremonial. But include the important functions such as appointment of the prime minister, governors. He is involved in the appointment of prime minister, governors, prime ministers and the council of ministers. They exercise executive powers vested in the president, responsible for the day-to-day administration. They keep accountable to the parliament. Legislative is simple 7, 9 to 1, 2, 2, right? The legislative powers. Parliament consists of the president and both the houses are included in the parliament. That is, the Lok Sabha is the house of the people and Rajya Sabha is the council of states. So the parliament consists of the president plus two houses. Lok Sabha is the house of people and then we have Rajya Sabha is the council of states. Now, parliament make laws. It is to control the finances and exercise oversight over the legislature. We have bicameral legislature because we have two houses with different compositions, functions, and ensures balanced legislative process. Now we have judicial branch from Article 124 to 147. 124, 147, 427. This is how somehow we need to memorize it. We begin at 2, right? 5, 2, 2, 8, 7, 8, 7, 9, 1, 2, 2, 1, 2, 4, 1, 4, 7. Supreme Court and High Courts. The judiciary interprets laws, protection of the fundamental rights. It protects the fundamental rights and adjudicates the disputes. Judicial independence is safeguarded through the provisions like appointment procedures and security of the tenure. Critique of separation of power in the India. We do not have complete separation of the powers like the American. Overlap of the powers is present over here. First, there is a overlap of the power. While the constitution delineates the powers between executive, legislature and judiciary, there is instances of overlap. Example, the president on Article 123 promulgating ordinances. It is an executive function and legislative powers vested in the parliament. Right. Executive control over the legislature. Executive influence over the legislative functions can sometimes undermine the principle of separation of the powers. The government's control over the agenda and legislative process in the parliament can limit its independence. Judicial activism. Judicial review is very important. What is judicial activism? Judicial independence is what constitution has provided. When the judiciary is making the policies or laws, there is a blurred difference between the judiciary and the legislature. When the judiciary makes laws, it is what we call it as a judicial activism. Judiciary makes laws. Constitutional amendments which gives more provisions to prime minister over the president. That is the concentration of the powers. Concentration of the powers in the executive. Executive concentration of the powers, challenging the traditional balance envisioned by the framers of the Constitution. Checks and balances. Despite these criticism, we have the checks and balances like judicial review, parliamentary oversight. Right. The judiciary has the power to review the constitutionality of the laws, executive actions, ensuring they conform to the Constitution's provisions. What is called as parliamentary oversight? When the parliament exercises oversight over the executive through debates, committees, motions, holding the government accountable. We have debates, committees, and motions also to hold the government accountable. Right. And an independent election commission. One of the most important points is separation of the powers. Under separation of the powers, you need to include the independent. I say that there is going to be an independent election commission. Right. To ensure that we have free and fair elections. To maintain the democratic processes. What is the conclusion? Separation of the powers in the Indian Constitution is not strict as the United States, aiming to ensure a functional balance of the power among the executive, legislature, and judiciary. Over the years, the system has evolved to address challenges and maintain democratic principles, although ongoing vigilance and periodic reforms are necessary to strengthen this framework and uphold the constitutional ideals effectively. The concept of separation of the powers is a foundational principle to ensure the checks and balances. Separation of the powers is where we be having the checks and balances to ensure checks and balances, right? And another keyword which we also mentioned is related to election commission, which is independent election commission. Independent constitutional and non-constitutional bodies can also be included for safeguarding these articles 51 and 50. Separation of judiciary from the executive is what we have article 50. Article 53 establishes the executive power of the union and it vests in the president, ensuring the separation of the executive powers from the legislature which is vested in the parliament. Article 74. Article 122, immunity to the proceedings in the Parliament from judicial scrutiny. 122 is the last article for Parliament, if you remember. 79 to 122. Immunity of the Parliament from judicial review, judicial scrutiny. Immunity from judicial scrutiny, right? Provides immunity of the proceedings from judicial scrutiny, ensuring the autonomy of legislative branch. Article 142, it grants the Supreme Court a power to enforce its decrees and orders of the Supreme Court are enforced. Orders and decrees are enforced, ensuring the judicial supremacy. So, Article 50, we know that, and 53 is when the executive powers of the Union vest to the President. Article 53 belongs to President, right? And separation of executive powers from legislative powers. That is, the executive powers of the unions are vested in the president and it is exercised by him directly or through officers subordinate is what we have article 53. Executive power of the union is vested to the president and he shall exercise them directly or through subordinates, right? Article 122 is providing immunity proceedings in the parliament, immunity to the proceedings in the parliament from judicial scrutiny. Article 142 is the Supreme Court is having certain power to reinforce its decrees and orders, ensuring judicial supremacy within its realm. There are again SR Bommai case emphasis on maintaining the separation of the powers and preventing an undue. So, because the president is making president's rule, right? It is subject to judicial review under SR Bommai case of 1994. So, here they say that there needs to be a clear separation of the powers to prevent undue interference of one branch of the government in the functions of the others. Undue interference of one branch of the government in the functions of the other. This case also underscored the role of judicial review in upholding the constitutional balance. We have Kesavananda Bharati versus the state of Kerala 1973. Supreme Court reiterated the doctrine of separation of the powers as a whatever you see important doctrines you have to mention Kesavananda Bharati case, and you need to tell that the Supreme Court has reiterated the doctrine of separation of the powers as a part of the basic structure of the constitution. It upheld the need for effective system of separation of the powers. We say that the separation of the powers, we need to mention about the checks and balances. Ram Javaya versus State of Punjab 1955. Indian constitution envisages a broad separation of the powers within its defined sphere. So this is very easy to remember. Ram Javaya versus State of Punjab 1955. Supreme Court held that the Indian constitution is having a broad separation of the powers between three branches of the government, with each functioning within its defined area. Now we are going for critical examination. Independence of the judiciary. Judiciary is having complete independence from the executive and legislative branches, ensuring impartial adjudication. Checks and balances. Among the three balances, there is also among the three branches, there is also checks and balances, right? To prevent a concentration of the power in any single branch. Therefore, there is no concentration of the power in any single branch. Among the three branches, there is a balance of power. And there is also checks and balances. To safeguard against a particular branch is having the authoritarianism. Judicial review allows the judiciary to strike down the laws and actions that violates the constitutional principles, reinforcing the separation of the powers. Criticisms is overlap of the powers, parliamentary oversight, judicial activism. In practice, there are instances where the executive and the legislative branches are overlapping. We see that the overlap is only between executive and the legislature, right? We have already read about these criticisms. Judicial activism, we had, you know, learned about judicial activism when even though there are separation of the powers, the Supreme Court, the judiciary is encroaching upon the policy making domains. The judiciary encroach policy making domains. So the critical argument is that the judicial activism sometimes blur the separation of the powers as courts may encroach upon policy making domains traditionally reserved for the legislature. Parliamentary oversight. Parliament oversees the executive. The majority party's dominance sometimes can weaken the effective scrutiny. When there is a majority party dominance, it is weakening the scrutiny and accountability, right? That is what mentioned over here. When Parliament oversees the judiciary, the Parliament is responsible for overseeing the judiciary. But when there is a majority party dominance, it is weakening this oversight. Now, separation of the powers in the Indian Constitution forms a robust framework aimed at ensuring the governance that is accountable, transparent, and respectful of constitutional principles. While challenges and criticisms exist, such as overlap in the powers, instances of judicial activism, constitutional provisions, and Supreme Court judgments continue to uphold the fundamental principles of separation of power. The ongoing evolution and interpretation of the judiciary plays a crucial role in maintaining this delicate balance, ensuring that no single branch of the government becomes overly dominant and unchecked in its authority. Now, this is a new topic, delegation of power. Right. This is discussed in next or upcoming videos.